Mr. and Mrs. BERCHIE-BADU got married in London in August 1970 and had 3 children. After 13 years, Mrs. BERCHIE-BADU brought a petition for divorce at the High Court in Kumasi. One of her main grounds was that her husband had fraudulently changed the land title of the matrimonial home at Kwadaso to only his name. According to her, it was she who purchased the plot of land on which the building was being put up, and accordingly, she wanted the building for herself and her children. But even as the divorce proceedings were still pending, things escalated. Mrs. BERCHIE-BADU filed 2 more urgent applications at the same court, demanding that her husband and his relatives be removed from the property immediately. But with each new application, her story began to shift. First, she had stated in her petition that she built the house alone. Then she admitted that her husband had indeed contributed. Cracks were beginning to show. Mr. BERCHIE-BADU, on the other hand, claimed that he had built the house alone and even contributed towards the land purchase. He stated that the building was not only for his children with his wife. He had other children with his ex-wife and girlfriends, as well as concubines, who were also to be beneficiaries of the same building. The High Court in Kumasi, after hearing the parties, dissolved the marriage. Custody of the 2 boys was given to Mr. BERCHIE-BADU, and his now ex-wife got custody of the last born, a girl. But what was the ruling on the matrimonial property? The court ruled that the plot of land belonged to the woman. Accordingly, all developments on the land belonged to the woman as well. Any contributions that were made by Mr. BERCHIE-BADU was done knowing full well that the land belonged to his wife. Mr. BERCHIE-BADU was stripped of all interest in the home and was further directed to pay 600 cedis for maintenance of the girl child in the custody of his ex-wife. He was understandably furious at the outcome and appealed. At the Court of Appeal, his legal team argued that the matrimonial home was built through joint effort. The judges listened and they found troubling evidence. Mrs. BERCHIE-BADU's account of the building's construction was full of contradictions. In one breath, she built the house alone. In another breath, her husband had helped. The appellate judges concluded that these inconsistencies were grave and should not have been ignored. Her contribution to the land was accepted, but her claim of contributing to the building was completely rejected. But there was something even more significant at stake, a question of law that would echo far beyond this case. Does owning the land, meaning that you own everything built upon it? Generally, yes. The ancient Latin maxim, quid plantator solo sedit, declares that whatever is fixed to the land belongs to the land, and the building follows the soil. In this case, the building was on the land. But this was not an ordinary case. This was a marriage, and the Court of Appeal drew a bold line. In a matrimonial setting, that Latin principle does not apply. What matters is contribution. Whoever poured their resources into acquiring an asset is entitled to a share. The numbers told a very interesting story. Mrs. BERCHIE-BADU could only prove that she had paid 150 cedis for the plot of land. The building itself had cost approximately 65,000 to 80,000 Ghana cedis. The court weighed the circumstances carefully. Mr. BERCHIE-BADU was already bearing the financial weight of raising his 2 children and paying maintenance for the girl in his ex-wife's custody. The High Court had also not provided any financial provision to Mrs. BERCHIE-BADU. Indeed, her lawyers only made a claim for a share of the property. Also, to deny a man completely of a share in the matrimonial property required very exceptional circumstances, and these circumstances were simply not present. So the Court of Appeal made the decision. The matrimonial home will be divided equally, 50-50. What do you think? Follow Super Law GH Studios for more real stories, real cases, real people.